Hi, everyone. Welcome to Unit 5, and I hope you've had an opportunity to read Chapter 5 of your textbook. And if you haven't, that's okay too. I will give you an overview here, and then you'll have an opportunity to read the chapter. So in this unit, the focus of the unit is really about having systems so that we don't get in trouble and miss deadlines and overlook important aspects of working in a law office. And the two areas focused on in this chapter are having a system in place to check for what we call a conflict of interest, and also a system in place for checking calendaring and docketing. So I actually did not make a PowerPoint for the second part about calendaring and docketing because I think that is relatively self-explanatory from the book, but I'm happy to entertain questions about that if you have any. Clearly, we know that deadlines and the calendar is really important in any aspect of any practice area. So definitely read that section of the book. But now I want to take the time in this PowerPoint to focus on the concept of a conflict of interest, because this is really critical for work that we do in a law office, and it requires a lot of upfront work so that we don't get in trouble later on. So I want to talk about what a conflict of interest is and the types of conflicts that we potentially run into, roll in some of those ethical rules, those rules of professional responsibility that we've had an opportunity to look at all semester, and then talk about what kind of systems that your law office can have in place and that you can help put into place to avoid the dreaded conflict of interest problem. As your book points out, missed deadlines and conflicts of interest repeatedly appear as very high repeated reasons why attorneys have ethical violations. So again, it behooves us to spend a few minutes talking about it. So let's talk about what a conflict of interest is, because we hear this word in a lot of other areas of life, not just in the legal office. But this really stems directly from that concept of confidentiality that we've been talking about in prior units, and that lawyers and those working with lawyers, paralegals, have to hold close those client confidences. What you learn from your client in relationship to their case and their lives, we can't go discussing that with our spouses, with our friends, with our loved ones. That's a violation of our ethical obligations. We learn a lot about our clients and their personal and their business matters through representation. And some of what we learn, we turn into legal action, right? If we're drafting motions or preparing documents on their behalf. But we learn a lot of other information too, and that's all part of a conflict. I mean, that's all part of confidentiality. And then we have an obligation to hold that information as part of our work in our law firm and not disclose it and share it outside of that. So that's really what this stems from, because we can start to see a scenario where we represent, let's say, a person who is involved in a lawsuit of some kind, a breach of contract or an employment discrimination. And we represent an employee in a lawsuit against her employer for employment discrimination. And we learn a lot about that employer and we learn a lot about that employee through that representation and that litigation. That information doesn't just leave our heads, right? We can't turn that information off. So if we're presented with another scenario where we have an opportunity to represent, let's say now the employer in a different matter, but we have this information that we know from the first client and the first matter, there's a potential for a conflict of interest. And what we mean by that is divided loyalties. The other ethical obligation that tends to fall into this idea of worrying about confidentiality and divided loyalties is that attorneys, and again, therefore paralegals, have an ethical obligation to zealously represent their clients. Give everything you can within the bounds of the law, of course, to represent that client. And if you have a divided loyalty between two different entities, you can't possibly be putting one of the client's matters ahead of the other one because your loyalties are divided. So that's in essence what we're talking about with having this conflict of interest, with being unable to put both your client's interests first and foremost, and what about the other interests. So let's just talk a little bit about the types of conflicts. Sorry about that. I got cut off. I got distracted and now I have to come back to my video. So sorry about that slight interruption there. Let's talk about the types of conflicts. We're going to talk about concurrent, past clients, imputed, and of course, personal conflicts. So concurrent conflicts means that clients that you're working on right now have a matter that you can't represent both the plaintiff and the defendant, right? That one might seem kind of obvious, but a similar scenario with types of conflicts that are concurrent would be representing two plaintiffs in the same lawsuit. You might not have a conflict, but that could present a scenario where you're representing two plaintiffs whose interests might be similar in some respect, but different elsewhere. And that could lead to, again, the problem with the potential for divided loyalties. So generally, no representing the same different parties in the same litigation. I mean, it's not automatic. You might be able to, but just something to be concerned about. What about past clients? Again, we can't really turn off what's in our heads. So the rules of professional responsibility recognize this. Even when a client of the firm is no longer a client of the firm, or you yourself have moved on and you are now working in a different law office, if you have a conflict with a past client, that is a conflict also. It's not like we say, oh, that was 10 years ago or 5 years ago, or I live in a different city now, I'm part of a different law firm now. The fact that you worked on the matter with a past client can present a present conflict of interest. So we have to worry about those also. You can see how the rules of professional responsibility take this very seriously by breaking down in their rules the different types of conflict. I also want you to be wary of the imputed conflict. This is where you yourself might have the conflict, but what about everybody else in the law firm? So we worry about the tainting. In other words, what if I have a conflict of interest because I'm new to the firm, I used to work on another matter involving this client, and now I have this conflict. Does that mean the rest of the law firm also has a conflict? And the answer is potentially yes. We'll talk in a few minutes about what you might be able to do in those scenarios, but the conflict is imputed. And that's because we don't have those dividers in a law office. People share files. We have open discussions in the hallways. Again, we worry about confidentiality in public spaces like a conference room or a foyer or a waiting area. But once you're behind the doors and you're working in the private law area with the lawyers and the paralegals talking and open files and access on computers, we worry that those confidences that we knew about from the prior client can now roll in and be the source of a potential conflict of interest. So we do worry that even though one person has the conflict, it can then apply to everybody. The last type of conflict to think about is actually a personal conflict. So far, we've talked about conflicts between, who you're representing, current clients, former clients, new clients, but you might have a conflict in your personal life. In other words, maybe you are the member of a board of directors of an organization that your client is looking at suing. Or maybe your spouse or your mother or your sister or brother work at an organization that is potentially part of a lawsuit that you're involved in. So it's not just about the clients, it's also about you in your personal life. So just something to think about when you apply to law firm jobs. They might ask you to share some personal information about yourself, but the reason is not to just dig into your personal life, but it's so that we can avoid the ethical pitfall of a conflict of interest. Okay, so the two steps that I want to go to avoiding conflicts actually picks up exactly where I just left off, which was talking about the employee himself, but we're going to focus on what we do with our own employees to make sure they don't have conflicts of interest, and then second, what we do about our clients. So the first one I wanted to mention is sort of what I just said, which is with all of the law firm employees who are working on client matters, we need to know this information. We need to know their names, maybe even former names if they had a maiden name or changed their name in their lifetime. We need to think about their prior employment and positions. So you might have been a paralegal in a different law firm, and the current law firm should know that. Maybe you were a manager or maybe an owner of a business before you became a paralegal or working in the law office, and we should know about that as well. We can also ascertain from our current employees the past clients that they worked with. Now, we do have to be careful, again, not to disclose client confidences. So it's not like you should share, oh, well, I worked on XYZ Corporation and I worked on, the details of the case. But you can disclose the names of the clients. That's usually not privileged or confidential information to say that, Smith Corporation was a client of mine. I didn't disclose what I worked on, but just the fact that they were a past client. Similar to what I mentioned before, if you as a paralegal are a director or a trustee or a partner in another entity, we need to know, in the law firm need to know about that to avoid potential conflicts because of that role. And last is, who are the close relatives and where are they working? You can imagine scenarios where you don't want to be working on a lawsuit suing your spouse's company. That is clearly, just rings like potential for conflict of interest, divided loyalties. You are representing your client zealously, but you recognize if your client wins, it could be a multi-million-dollar lawsuit against the company where your spouse works. That doesn't sound so good. You don't want your spouse's company to go out of business or something like that. So it is very normal and expected to go through this screening process with employees to avoid potential for conflicts of interest. So that's only step one. What about step two, which is the clients and the potential clients? There's some good samples in your book of what a conflicts check sheet can look like, but in your law firm, there will be employed a system to check for conflicts. It's called running a conflicts check. And the lawyers in the law firm routinely run a conflicts check for any new client and even for existing clients for new matters, right? Maybe they represent Smith Corporation in the formation of their company, to make it a corporation, but then a year later, we, the same firm, want to represent Smith Corporation in a lawsuit against Jones Corporation for non-payment for some services. That's the same client, but it's a different matter. So we do need to make sure that the conflict doesn't extend to that. So how do we make sure there's not a conflict? What we need is a system in place to make sure that everybody's aware of who the client is and what the matter is. So that is why initially we get some information from the client. Who are they, right? What's the name of the entity if it's a company? What's the name of the person if it's an actual person? And I just want to mention a little bit here about who the client is. And this is a little bit discussed in your book, but I think it's really important in a representation of anybody, whether it be a corporation, a limited liability company, or an individual, to make sure we know who that client is. I'll give you the example of a corporation. It is possible to represent a business because a business is its own legal entity. But that sounds weird, right? Because we don't just call up the walls of the business. We have to actually speak to a person. So when we represent a business, again, think like a corporation or a limited liability company, there's going to be an officer of the corporation with whom we speak that is speaking and has the authority to speak on behalf of that corporation. So maybe we talk to, I'll just use myself, Hallie Sugarman, the vice president of Smith Corporation. So when we are representing our client, we're talking to the vice president, Hallie Sugarman. But think about this for a minute. What this means is you're not representing Hallie Sugarman in my personal capacity as a person in my own life in any matter that I have. I'm just speaking on behalf of the corporation. I'll give you another example in a minute, but I see that I'm at 14 and a half minutes. So I will stop this video and finish it on video number 2. And then we'll finish this part about screening our clients.